It is June 19th here, and thank you for joining our webinar here, hosted by the Bering Regional Center team. We have some new data, new items that are popping up here in our EB5 world, as well as new facts and figures that are helping us make better decisions in EB5, and we wanted to share those today. And most of all of this actually centers around the idea of processing times and approvals and how long it takes for EB5 to actually deliver green cards, as well as all the petition approvals that come in the middle. We're going to talk about the successful strategies and things that go into some of the source of funds filings as well, and items that we've learned from USCIS and that process, and then also diving really deep throughout the entire presentation into new data released by USCIS, released by the Department of State, and what we've learned from all of this. Today, the Bering Regional Center team is joined by Feng Lei, esteemed attorney at KLD, and a longtime friend and partner in the EB5 industry. And we're going to try and blow quickly through some facts and topics and then get to Q&A toward the end of the video. This is an interactive presentation. We're going to be releasing polls. We're going to be releasing information and downloads. There's going to be ability to click links to get to other blogs and informational websites and presentations. Feel free to dive into all of this stuff. This presentation is for you guys. It's for everybody in the industry, and to share ideas, questions, comments, and all of that. Speaking here today, you're going to have myself, Colin Bering, the CEO at Bering Regional Center, as well as Peter Bibler, our managing director, Greg Sheehan, our director of USCIS compliance, and a former USCIS adjudicator, with that inside look at what goes on behind the scenes there. And as I mentioned previously, Feng Lei at KLD, longtime friend and attorney in the EB5 industry. Moving on to the first topics of discussions. All these EB5 investors and everybody that's looking at the program in its very early stages today all want to know about processing times. How long does this take? If I invest $800,000 of my hard-earned money, when will I get the benefits that I signed up for? Today, we're going to talk about really the policies behind it, and then the items and considerations and interruptions that may or may not show up in those processes. At this point, I'm going to hand it over to our team, and they're going to walk you through, because Peter, Feng, both immigration attorneys, Greg, an immigration attorney, plus his benefit of USCIS adjudication history. They know much more than I do about any of this. So I'm going to hand it over to you guys. So go ahead and take it away. And thank you first and foremost for being here.
To get us started here on factors of the impact processing times and I-526E approval. And I-526, for those out there, is the initial EB5 application that you're filing that kicks off this whole process. Just as context for all this is, we do the best we can with the limited amount of information that we have. USCIS isn't the most timely or even the most productive in terms of accurate, timely production of information to give us the data that we need to make the informed decisions that we need to make when choosing a project or choosing an investment option for the EB5 application. That comes in fits and starts, and we try to triangulate from there. Based on our experience and based on the data that's being provided by USCIS and by the State Department, we're aware of many factors that go into play here. One of the things that we've seen, and we'll go into detail here in a second, is that while we've been very successful, we've seen post-RIA, post-Reform Act, I-526E approvals, they're not as fast as in coming as we've hoped. And this is both good and bad, and we'll explain why. One is USCIS is actually recent months has shifted priority and focusing on pre-RIA petitions and catching up. And we've seen dozens of approvals even in Bering directly in the past few months. 2 years later, after the implementation of the IRA, the IPO office at USCIS is still taking a long time trying to integrate all the new components of the IRA. And I think that's a significant factor in processing times that we'll talk about. Case complexity is one, of course. Greg and Feng have seen this on both sides, filing attorney and adjudicator. We've seen investors approved as fast as 7.5 months. And some of that can be just based on the simplicity or the complexity of the source of funds. And that's where working with a good attorney, an experienced attorney, is crucial. This goes to the accuracy and completeness of the documentation. We're going to talk about these strategies in detail later in this webinar. A couple of viable strategies that you could use to be able to file immediately or sooner so that you can start this whole process and get the benefits of the green card very early on while you wait for the actual green card to come. The scary words here we see are RFEs and NOIDs, requests for evidence, requests for clarification, notices of intent to deny. Here, the best method to deal with these things is to prevent them from occurring altogether. And because while getting an RFE is not fatal to your application, you can still be approved. It can not necessarily delay the approval of your petition. So having the right partners at the very beginning and taking the time to file a substantive and quality application with a source of funds report is crucial, just to avoid it altogether. And we're going to talk about these last couple of points here, USCIS staffing and priority processing kind of in detail, because they do actually have an impact on some of the numbers that we've seen published recently this past month. Recently, in timing with this, we've seen the visa bulletin for July issued. One of the key takeaways is that it's current for all visa set-asides. So if you're not familiar with this, we have, as you can see here, fifth visa preference. This is EB5, and we have 4 categories. This is all post-RIA, Reform and Integrity Act. So the Reform and Integrity Act of 2022 established these lines between set-aside visas, which are rural, high unemployment, or infrastructure projects, and the fifth unreserved, which is the non-TEA or unreserved visa. This is the $1 million project. In these visa set-asides that we're focusing on, and that's what most regional center projects offer, are set-aside projects such as rural or high unemployment projects. These are current, and by having these as current status means that investors in the United States contemplating filing EB5 now have the advantage of concurrent filing, meaning you are able to file your EB5 petition and your I-45 adjustment of status application at the same time. And the benefits of that are crucial. We can't really understate the benefits of that. One, you have immigrant visa status, pending immigrant visa status. It's a protected status. 2, you're able to get an EAD card and the advanced parole. EAD here is the work authorization. It looks like a green card, but it gives you the benefits of the green card. So you can work wherever you wish, take any position that you'd like, open up your own business with that EAD card. And that comes in just about 3 months after you file. So that's something that real tangible benefits that you get in a very short period of time. And very often, this is often a crucial issue for many EB5 investors today who are facing extended visa backlogs in EB2 and EB3, where their children are becoming teenagers. And they're looking to college, they're looking to future employment, and they're risking aging out because of these extended backlogs you can see here in the EB2 categories. Like for India, for example, it's still in 2012 here. That is the child status age protection. So by virtue of filing the I-45 adjustment of status application, you're able to lock in your children's ages to prevent that risk of age out under the EB2 preference that they otherwise might risk in that category. That's the key takeaway here. These things remain current. According to the State Department last month, these categories are expected to remain current possibly through the entire 2025 next year. That is good news for investors in the United States considering filing their applications.
Can you elaborate for a minute? With most of the post EB5 investments coming through these set-aside categories, why is it that the visa bulletin is projected to remain current for so long?
A couple of reasons here. One is the processing of petitions. We have a number of petitions that have been filed for post-RIA. They need to be approved. And once they become approved, then you're sent to NVC or they go through the adjustment of status process. And once that person becomes documentarily qualified, then those visa numbers are assigned. And that's when you'll start seeing visas being used in these categories, and when we might start seeing final action dates imposed in these categories. But there's a couple of reasons that we're not seeing that occur. One is USCIS is prioritizing the processing of pre-RIA petitions, and they are trying to just avoid visa wastage. There are, what is it, Greg? Like 14,000 plus
Correct.
visas available this year. And in years past, like during COVID, when they were working part-time, consulates were closed, they were not exhausting those visas, and visas were going to waste. And so here there's a concerted effort, and we've seen this in our own projects, our own investors getting approved, to exhaust those visas and prevent visa wastage. The second reason for that is, so they're focused on pre-RIA, getting that backlog knocked out. So fewer visas are being taken by post-RIA investors. Secondly, post-RIA investors that are getting approved, many of these investors are being allocated unreserved visas in the same fiscal year. This is something we discussed repeatedly very early on. I think we were one of the first groups to kind of highlight this, and it's now finally, I think the market is catching up because we're seeing more of these visas being issued. And what I mean by this, and Greg, elaborate where I leave off. When you get your I-526E approved, you're going to see two visa codes on your approval notice. One is for an unreserved visa, one is for a reserved visa. And last month, the State Department publicly stated that you're going to get a notification, you're going to make an election whether you want to be processed under the reserve visa or the unreserved visa. If you are in the rest of the world, you're born in Canada, you're born in France, even though you chose or you invested in a project that qualifies for the reserve visa, like a high unemployment urban HUA project, you could still choose to be processed under the unreserved visa. And this is great news. We saw this early on, we predicted this, and we've seen it bear out in practice where in that same fiscal year, the rest of world applicants are getting unreserved visas. And this actually frees up more of the reserved visas in that fiscal year for high demand countries like folks from India, folks from China, and so forth. And that's going to mitigate any potential backlogs going forward. And that's probably why we won't see something in 2025.
Yeah, it's certainly helpful that the government had the foresight to put that into play, knowing that all demand incoming post-RIA was going to go through these categories, but they're still able to leverage the unreserved categories, which, by the way, if not used in the fiscal year, they leave EB5. The set-aside visas enter every year. They stay there for a year if they're unused. And if they're again unused for a year, they go to the unreserved inventory where they're subject to wastage. That's why maximizing visa use strategically has the true priority here for visa processing is the unreserved category. When it comes to giving somebody their green card, that's not part of the IRA, not part of the RIA. That's part of sensible business to make sure that you use as many visas as possible. Otherwise, they get wasted.
Okay. So everyone, we're adding questions and polls as we go. And it's really helpful to everybody in the room, all 84 of us, if everyone participates, because I think we're going to discuss some of these outcomes and some of the answers that we have. Some of them are going to be extremely surprising. So if we can get everybody's participation in there, all the guessing, all the dart throwing, and then also just validation of what you're hearing out on the market and what people are telling you. And we're going to ask our professionals here at the end during the Q&A, is it myth or fact? Is it true or false? The more insight we get from these polls, just please go ahead and click in there and let's have that discussion later. Thank you.
So with this slide, it really highlights recent demand. There was a recent surge in filings reported by USCIS, I think, in part because the fee increased in April. So a lot of people filed in the first quarter. We're up to 5,344 total. There were over 1,800 filings in Q1. Post-RIA, again, with focus on the unreserved backlog being the primary goal of USCIS, it's no surprise that only 429 526Es have been approved. And so this is problematic for those who are chasing a fast green card. The more people trying to get that outlying data point, the more you have a bottleneck, the more you have a rush to something that cannot be delivered. It's statistically impossible for the government to do that. But this is a big increase over the past 6 months. We hope to see this trend continue of adjudications to speed up. But the reality is, as the State Department reported, only 12 reserved visas were allocated overseas and 5 HUAs. And that's an equal distribution of their relative inventory. What we don't have yet is the number of USCIS approvals that have been processed yet. So that will certainly add to the count. But we are seeing some investors get closer to the finish line here. So it's not all doom and gloom, but it is almost impossible to get anything done quickly. As Fong will tell you, he's been doing immigration for years. Fong, is there any way to get a fast green card? Is there any way to skip the line at this point?
I mean, part of having a democratic legal system is typically we're all on the same lines, right? We're all subject to the same things. There are case by case. There's always this myth or this theory of expedited processing, but by and large, that's going to be investor specific. You're going to have to prove some sort of like extremely personal, urgent circumstance that the family member, severe financial loss or harm. Otherwise, it doesn't really apply.
Right.
We have had an post-RA investor successfully proceed on an expedite request and was approved in approximately 12 months' time. The actual expedite itself was very fast. Once the expedite was filed and approved, the expedite request was approved, the I-526E was approved in 2 weeks. And that's actually faster than what I've seen expedite requests. Usually it's something you'll get maybe 3 to 6 months after an expedite request approval. So that was really fast. But like Feng said, it's individual specific. So if investors have compelling circumstances where they may be eligible for an expedited approval, then it's something to consult with your attorney on, like such as Attorney Fong here, to evaluate that and see if that's possible. But it has been done post RA with Barry.
I mean, I'll give you an obvious example. If you are in some sort of profession or some sort of job that will greatly fill the need of the US populace or the government or some public policy version, you have a case for expedited processing, such as if you are a medical professional that is servicing some hard-hit COVID-stricken area or an area that has a lot of rehab patients and they need medical professionals, you have a personal case for expedited processing. Whether they grant it or not, it's a whole different issue, but it is something that, people have explored and they've been successful with it.
And just to restate the above point, where the reserved visas, if they go unused, they go to the unreserved category. So what we see here is, I think that there's 5,000 rural visas available, which sounds like something to celebrate. But if they're not used, which they won't all be, significant amount are just going to flow up to the unreserved category. And that trend should continue unless IPO can just not, or unless the service can knock out an inordinate amount of visas, which is unlikely, but hopefully they can speed up.
Yeah, we've already actually had nearly 6,400 visas, post-RIA visas, get carried over. And from 2022 to 2023, and then from 2023 to 2024, they're lost. So we lost 6,400, nearly 6,400 visas in the reserve categories because no visas were issued in 2022 or 2023. Or very, 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 very few. We say they're lost, but what happens is that they go to the unreserved category and they get applied to the existing backlog for China and India. And that's good news. So I mean, it's not like it's completely lost, because as soon as those backlogs are alleviated, then it frees up more visas for everybody going forward for India and China in these reserved categories in the future.
Move on to the next one.
This is a great snapshot. I worked for IPO in 2018 up until 2022, and I know exactly what that says. We were fully staffed pre-COVID and pre-policy changes. The Modernization Act put a challenge into filings that we had to fight on behalf of the industry and revive it in our Bearing lawsuit. But what you're seeing here towards the right, and thanks to Suzanne of Lucid Text for putting this together, the purple blocks are post-RIA approvals. That needs to pick up significantly for people to actually get a fast rural green card, right? So you're looking at facts here, not sales narratives. You might have seen somebody get a green card in 7 months. That's an outlier. So when you are betting your life savings and more and putting your family in the best position possible, you have to be very realistic about the difference between marketing and fact, which is related heavily to policy, to understand which visas are actually given priority, which is the unreserved category.
Yeah, this slide is exciting. As I mentioned earlier, we're finally seeing a huge amount of activity after years of drought. This is preventing visa wastage. It's moving people forward in the backlogs for India and China, who have been languishing for some years, especially Chinese investors who have been, since 2016, 2015. Been waiting for their processing. Because just to remind, if people aren't familiar, a couple of years ago, USCIS changed policies on how they process I-526 petitions. This is also important to raise because when you go on to USCIS website and you search processing times by form, you're going to see these crazy long processing times. And you do need to click on the fine print because they do have definitions there, and they explain that the majority of those, overwhelming majority of those petitions are actually at the front, the left-hand column, not the 60-month or whatever it is on the right-hand column. And the reason for that is a couple of years ago, USCIS changed policies and switched from, kind of an unknown, murky, who knows how they process, to a visa availability approach to processing the I-526 petition, which meant that if in your country of birth on the country of chargeability on the visa bulletin, if you were not current, meaning you do not have a visa available or imminently available, they were not going to process the I-526 petition. And so that actually meant that for especially China, that they would just put all these petitions on the shelf for years. And that's what caused those extended timelines to be posted on the website. And to a lesser extent, India as well, for pre-RIA Indian investors that filed like in 2018, 2019. What we've seen now is visas are becoming current or moving forward for pre-RIA investors. And we're seeing a slew of I-526 petitions being approved. And just by way of example, like for our last project, 1900 Broadway, which had a significant number of pre-RIA investors, like all those have been are starting to get processed. And this just in the past, I would say, what would that be? We're in June, maybe 3-4 months. We've seen dozens of approvals come through, catching up all the way through 2021. And June 2021, to know your important EB5 history, is right before the government shut down and the program stopped for nearly 9 months before giving birth to the Reform and Integrity Act of 2022. As USCIS catches up to those 2021 priority dates, this is especially important for India, that we're going to start seeing that pre-RIA backlog be rectified here in the near future. I think chart B is still April 2022. That's typically where the State Department thinks that the final action dates will be at the end of the fiscal year. It's not always the case, but that's what the predictor is. Last month, the State Department official publicly said they expect significant advancements come October for fiscal year 2025.
Yeah.
So this is
and
great.
I think we see that playing out in real time. Right. There's especially been an uptick in the last quarter, the number of approvals rolling in for pre-RIA investors. We're seeing people who have priority dates of 2019 to 2021, substantial amount of Chinese and Indian investors. So I think they're really making a dent in that backlog. There was a period in the last year or two when people were having 526E approvals. That's largely slowed down for the most part, and it's kind of borne out by this chart right here. However, it doesn't mean that IPO is not working. They clearly are. I think that right now it seems like a lot of their focus is based on clearing out a lot of the pre-RIA backlog.
So yeah, as Peter just mentioned, the benefits of concurrent filing allow you in the United States, if you're an H-1B, you're immediately decoupled from employment-based immigration. As soon as you file, that you control, you can start the clock towards your EAD, get a priority date, depending on your country of birth. The earlier you get a priority date, the better. So we can talk about strategies to actually move faster than waiting for a full 800K to be in your pocket, but protecting the age of your children, getting them into internships, giving them a new status and a pathway that is not H-1B. It's not stuck in the lottery process and things like that. So a significant amount of Indian-born investors in the tech area, in the Bay Area where we are, like our product. They like the economic strength as opposed to most rural areas, which by definition have low populations. So that can be scary. But with both investments, whichever one you like, you know that you're going to be able to file concurrently. And according to the State Department, that opportunity is going to remain for at least 12 months from now. So there's a significant runway for you if you're just starting to look at EB5 now.
Yeah, and I think of all the changes in the RIA that came about in 2022, you think about a lot of like the hand wringing, a lot of the stress, a lot of the anxiety over the immigration process. It's anxiety of not knowing how your life will play out in the next year or two, not knowing what employment opportunities you have, not knowing where you can put your kids in school. I think of all the things, so what we focus on when we look at the data is what has predictive value, what actually helps you and your family plan out your life in the US. And so of all those things, so I want everyone to think of processing times almost as you have two separate timelines, right? One is your green card timeline. Yes, your 526E approval, your 485 approval. You can't control that as much. It seems to shift up and down. There are some cases being approved and there are obvious outliers. Some are 45 days, some are much longer than a year. However, what you can control is your benefits timeline. As soon as you can currently file, you can remain in the US in lawful status. We know that for the vast majority of you, within 90 days, you'll get your EAD. You can work anywhere, you have freedom from your employer. Within 5 or 6 months, you have your travel document. So live, work, play, travel, just like a normal green card holder. I think that freedom is liberating for a lot of families.
Yeah, and I think just to reiterate on one of those points is the uncertainty of processing times, and it's something outside our control. It's outside the regional center's control. It's outside your lawyer's control. It's outside your control. We have seen and experienced that it's not always first in, first out post RIA. There is a lot of marketing, some more aggressive than others. I think you just need to be mindful of that. It's hard to plan your life around marketed times. And, we have seen in our post RIA filings, we've seen an approval as quick as 7.5 months. Just about 4 weeks ago, the person was approved in about 7.5, 8 months time. But we've seen rural projects, announce approvals in 15 months, which is the differential is at least now, if you're filing now, like the differential of the times that we're seeing is much narrower than what's being marketed. The marketing that we've seen, the most aggressive kind we've seen, is really referring to something that occurred in early Q1 2023. And, that was largely for a couple projects that were already established. They already had 924 approval and had a mandamus action to get the 956F approved. And there were very, very few post-RIA petitions filed at that point in time. It's a different landscape now and harder to predict in some manners. Like I said earlier, USCIS doesn't get, is always the most timely or forthcoming on information. And even when that does come out, it's usually limited. We don't really get it always broken down by country or broken down by visa set aside category. When we mentioned in our last webinar, and I don't think we have a slide on this, but I'll just highlight it here. We mentioned in our last webinar that we filed a Freedom of Information Act request with USCIS. That is in process right now. So we actually expect to start getting responses and updates soon. Hopefully by the end of this month, we'll begin. And so when that information comes forward, we'll share that with the public. It'll take some time because they're going to be giving us like hundreds of pages of documents that we'll have to sort through, but we're hoping that will bring a little bit more transparency to this process. We've also asked questions about definition of priority processing, the implementation of the dual visa codes and so forth. So we're hoping to have more understanding on all these issues going forward in the very near future.
Yeah, to your point, the initial rural approvals were able to get a 956F because their 924 was delayed. If the 924 was adjudicated on time, they would have lost the opportunity to file that for you. Not every case happened that way, but we've seen that. And if they weren't given visas just because they were rural, they want a mandamus, So that scenario is no longer on the board. To the point about set-aside visas having lower processing priority than unreserved visas, State Department said that they're going to clear 14,000 unreserved visas this year. They are probably in line to clear maybe 400 set-aside visas. It's a significant disparity. But the set-aside investors who have the opportunity to get an unreserved visa, which is rest of world and in the future India, will be able to get the benefit of that visa allocation as a priority.
So at the end of the day is that there are no shortcuts. I mean, there are no shortcuts to this whole process. There's no shortcuts to choosing your project. You should always go through a due diligence process, make sure all your questions are answered about the project, about the investment, consult with attorneys, consult with investment advisors, and make the best decision. If speed and processing times are uncertain or speed is becoming less and less apparent for the rural category, what you can control is filing and obtaining a priority date, the first step in that process. If you're in the United States, you can take advantage of concurrent filing, which enables you to get the benefits of the green card in about 3 to 4 months and locking in children's ages if appropriate for your case. And 3, selecting a high quality project and a reliable and experienced regional center operator. These are things that are in your control. So I think, we're going to spend some time now on a couple strategies that we offer at Bearing and kind of talk about them both, in the context of what we offer, but also in a broader policy context and as a source of fund strategy with some insights from.
Yeah. But, to Peter's point, a big thing is control what you can control. There's no point in stressing over all, so much academic ink has been spilled about these various analysis, but control what you can control. Your life will be a lot easier, Talk with us. We'll help you out however we can. And now I guess you're going to introduce this slide, right, Peter?
Sure, I can. A few approaches here. One, installment plans, investing over time. At Bearing, these are EB5 investments. That's what this is, an EB5 program, but we don't treat it differently just because you're getting a green card versus investing in a private equity fund that you would normally do. So the strategies that we offer are things that you would normally see in the private market anyway. Capital contribution schedules, using a variety of source of fund strategies to invest your capital, and answering your questions and getting the information that you need to make to complete your due diligence process. Again, there are no shortcuts. These are just tools that help you achieve your goal in filing an EB5 application with a reliable and quality project. Installment plans, these are partial payment plans. Basically, as long as you can demonstrate that you're committed to the investment, irrevocably committed to the investment at the time of filing, you can start an application with less than $800,000. We've done this since 2016. We've always had it approved, and we've had dozens of approvals over the past several years in Bearing in particular. With this, I'm sure Fung has probably seen more with installment plans. Self-directed IRAs. We've talked a lot about installment plans in the form. Today, we want to highlight in a little bit more detail self-directed IRA accounts and unsecured loans. These are strategies that investors have started taking advantage of this past year, a year and a half. We want to demystify these items here. So self-directed IRAs. First of all, what is it? What are we talking about here? What we're referring to is IRA retirement accounts that you may have, like at Fidelity or some other brokerage, or former employer 401k accounts. And you're basically taking those two types of accounts and rolling them over into a self-directed IRA. And you're directing the IRA on your instructions to invest into the EB5 project. The advantage of that is there are no loan fees. Like, you're not taking a 401k loan and incurring interest and taking fees on that. There are no taxes or 10% penalties for early withdrawals, because it's not a taxable event to roll it over from one IRA or former employer or 401k into a self-directed IRA. And you maintain those tax advantages depending on whether you're doing a traditional IRA or a Roth IRA. You can do both, but it is something that gives you extra flexibility as a potential source that you may not have realized that you could use before. From your perspective as a practitioner and preparing source of funds reports and kind of advising clients, obviously here we're not giving specific legal advice. If you want to talk about your specific situation, then we encourage you to make an appointment, one-on-one conversation about the specifics. But generally, can you share a little bit about your experience with these self-directed IRAs?
Yeah, I mean, at this point, we've probably have filed cases with dozens of self-directed IRA accounts. To me, there's nothing particularly exotic about them. I know there's some pushback, there's some fear, there's some trepidation from other law firms or other regional centers who the basic question or the basic concern they have is this: we've never had a self-directed IRA approval. We don't know if it works. So therefore, we're going to be conservative and not use them. So that is one school of thought. Our school of thought, and what we explain to our clients, is simply this: if you lawfully earn money and you own that money in an investment account, for what reason can you not use that to invest in anything you want? So the money is yours, you pay taxes on it, you are directing your account to invest into a private placement such as Bearing's EB5 project. That's a standard investment process in our opinion. It does have to be set up correctly. It does have to understand that when you set up these self-directed IRA accounts, some common misconceptions are they are not a withdrawal. You're not taking the money out early. Please don't do that, because we don't want you to lose a bundle of money. You're simply rolling it over to an IRA account that you control and you can invest in. I think it's also important to understand that this whole concept of using a custodial account is not new in EB5. There have been other situations where our investors have used custodial accounts in order to fund or subscribe on behalf of the investors, and they have been approved. A basic example is we've had a variety of reasons, minor children, 13 or 14 years old, who may or may not have the capacity to sign a legal investment contract, right? In those instances, if the parents have gifted them the funds and the parents and the investors own the funds, the parent can actually just sign as custodian and the child will still be the investor. Those cases have been approved. This is the same exact analysis in our opinion. So there's nothing exotic about it. I think the benefit to investors is this. When we have discussions with the clients about funding $800,000, it's hard in today's world for someone to just have $800,000 liquid, $800,000 cash. So usually what happens, and those of you who've talked with us know this, we sit down with you, we try to figure out what buckets of money you have to draw from. It might be a HELOC, it might be some money you have in high yield, it might be vested RSUs, but usually one particular source is going to be money you have saved up in retirement account. And so when we go over with our clients, what we realize is a lot of you have money saved up because you're financially responsible in a 401k account. And the concept of being able to roll that over and use it tax advantage for EB5 is a huge deal. So we like to save our clients money. We like to make their lives less stressful. And that's why we work closely with certain self-directed IRA providers and Bearing to set up this option.
Fung, is it only an option for former employer 401k accounts, or is it possible for a current 401k or a 401k account with a current employer to roll over into an IRA? And is it only the primary applicant's account, or can the family use the spouse's retirement account as well?
Good question. In terms of whether you can use a former employer 401k account or IRA account, it's not controversial. It's easy, right? I would say if you're working with, if you have a current 401k account that you have funded and you're still working for that employer, check with that 401k provider. In our experience, some allow you to do so, some don't. Some even allow you to switch over from 401k in a self-directed IRA in the same account. It completely depends on your program, right? So it's something that if you're interested in doing EB5 with, it's something that you want to set up sooner rather than later. So just, it might be the only time you check your investment offering documents, but it's a good time for you to do so. In terms of whose account you can use for a self-directed IRA, it's much like the same conversation we have with when you go through EB5. Pick one person to be the lead investor, because that lead investor, that lead subscriber will be the person that you draw from the self-directed IRA, because essentially you have one subscriber that owns the funds, and that's how you would use it.
Got it.
Okay.
The other source, of course, is unsecured loans. We've talked a lot about this in the past. You've written and spoken publicly on this strategy several times in the past as well. So just to have share your insight to participants in today's webinar will be great, given your experience. But just unsecured, just to give some background to set up this conversation. Traditionally, for years, USCIS required that an investor using loan proceeds to fund their EB5 investment required that the underlying loan be secured by your real property or by your personal assets. Had to be a secure, money coming from a secured loan, one way or the other. Now, there are many stakeholders and attorneys, and over the years, always thought that this was a misinterpretation by USCIS, and there was a federal lawsuit that brought this issue to the forefront. And USCIS lost that case, and even lost it on federal appeal. And this was back in 2020, I believe, when they lost the appeal. And that essentially just became the settled law of the land, that unsecured loans were an acceptable source of funds. And this could be a personal loan from a family member or a friend, because sometimes gifts, which is a very common strategy, a gift from a family member or a friend, could entail tax considerations, or there might be other reasons where that family member or friend wants to structure this as a loan, but in the past they could not. After the Jong case, that became permitted. It still requires a source of funds documentation. You're not avoiding that. You still have to go through that. But personal loans are permitted. Unsecured loans, importantly, are permitted and have been approved. Even for some of our investors who've relied on personal loans, unsecured loans have been approved. The key, of course, is how they are structured. And Fung, we want to get your insight to kind of share about what is necessary to ensure that an unsecured loan as a strategy would be approved by USCIS.
Right. And I'm glad we got to this part of, it's funny because as EB5 matures throughout the years, right, we touch on areas where in every other financial investment field, they're very normal. But for some reason, every single time we run into it with EB5, if it's a point of first impression, there is just a population that gets scared. They tell you like, oh, look, I don't know, it hasn't been done before, so I don't know if it will work out. So for unsecured loans, the basic analysis is this: is this a bona fide loan transaction or not? is it real, right? Is it a real arm's length transaction? A very common one will be, and a number of investors have used this, if you go to, say, SoFi, or you go to your local credit union, and you ask them for a personal loan, they might extend you anywhere from $50 to $100 or $200,000. Unsecured, right? It's basically like a line of credit almost. I don't see why that is controversial to use for EB5. How different is that than getting the same loan, but using your house as collateral, you know? In the end, the source of funds is relatively straightforward. It's the bank's money, it's the credit union's money. It flows to your account. So long as you went through a standard underwriting process and it looks like a normal loan, it should be approvable.
So, Fung, the challenge question that comes up is, well, I look at the USCIS website, and under the definition of indebtedness, it says that I have to own the collateral that I use for a loan. And there's an ellipsis there that wasn't written in, which would say, yes, if you're using a secured loan, you have to own the security. That doesn't prevent anybody from using unsecured loans, but that's where the confusion is because of the uncertainty of the way it's written. I think they could have done a better job. I think they were talking about secured loans without trying to exclude unsecured loans. Now we're seeing approvals come in with no issues, no RFEs. What do investors need to know? It needs to be legitimate. It needs to come from a lawful source of funds. And I think an important note is that it needs to be repaid with a lawful source of funds as well.
That's a good point, Greg. And shocking that there would be immigration instructions or things on USC's website that's not entirely clear. It happens, right? It's nobody's fault. We get it. And that's what we're here to help demystify. You know, the two basic type of loans you can take are secured and unsecured, you know, either collateral or no collateral. For years and years and years and years, everyone has only used secured loans or loans with collateral, most commonly using your house. So why would you use unsecured loans then? You know, why would you not use a secured loan? Well, unsecured loans, for a variety of reasons, they tend to be more flexible. They're more expensive. They offer you access to a different line of capital, but if you qualify, you qualify. What's important, and I say this too, is that not all unsecured loans are the same. You do actually have to read through your loan agreement and make sure that you're eligible to use it for EB5. What I mean is, even if the funds are clean from the bank, even if they give it to you through a standard underwriting process, look at the terms and restrictions. If they give you whatever you want with it, perfect. If there's a line in there about how you cannot use this loan for securities or brokerage account, you cannot use it for EB5 because EB5 is a security. When our investors go through this process and they're exploring various personal loans or unsecured loans, we tell them that before they actually take out their capital, let us take a look at the agreement first before they use it.
What's your thought about, I mean, you know, this last point here, it talks about consistency with immigration laws. And this is important because the Reform and Integrity Act clearly lays out that gifts and loans need to be made in good faith and that they're not means of circumventing the lawful source of funds requirement. So that's why these loans need to be properly structured. Repayment of the loans need to be, you know, contemplated with lawful sources. We've had that question, so I just wanted to, I think you may have mentioned it already, but the repayment of the loan. Is there a time frame, like a minimum time frame that they need to hold the loan before they repay? Do they need to be prepared to document the sources of that repayment? Can or will USCIS ask about the repayment of the loan?
Good question. And I think part of this is what it comes down to is a credibility issue. Usually, even though it's not strictly required, we'd like to provide background about who is the lender behind the transaction and what the investor's reasons are for taking out the loan, right? It kind of like provides a more common sense situation for them to get. Let's go to consistency with immigration laws and also repayment. If you are taking out a loan, it cannot be some sort of weird transaction that you're using to circumvent immigration laws. What I mean is if you wanted to give a gift to a friend, but now, you know, you want to give a gift to your friend, but you realize there's tax issues. So you give them a 0% loan, which never needs to be repaid. That just smells funny. That just looks funny. And if anything, USCIS will strike that down as a fake transaction. It's not a true arm's length transaction, right? That's one example. But if you're taking out an unsecured loan, because look, you have, say, 1,000 RSUs that will vest in the second half of this year, but you want to access money now, that to me makes perfect sense. It makes common sense. It's a credible explanation. In terms of repayment, both Peter and Greg are right. You need lawful money to repay these unsecured loans in the future. But what's going to happen is you have a timing issue. If you repay your unsecured loan or any loan for that matter before 526E approval, USCIS is well within the rights to ask, where did the source of money come to pay back these loans. If it's paid back later on after approval, they typically don't ask. And that's something we can discuss during a consultation later on.
Yeah, it's always been our general guideline to tell people that be prepared to document. It may not happen, but you should always go in with that expectation of using, being prepared to document the lawful sources of the repayment of the loan. There have been some instances, right? Not common, but there have been some instances where even at the 829 stage, sometimes there's a review of the source of funds or questions about the source of funds. That's occurred, right? Not common, but
yeah, it's always possible. It's always possible. So, usually we've had situations where people have taken out all 500, all 800, well, all 500 because this is back in the day, all 500 from one unsecured loan, right? Mm-hmm. This person was a very wealthy business owner. He had a very good relationship with a bank in Japan. A bank in Japan gave him an unsecured credit line of $2 million. We had a grant letter, we had the funding and everything else. That case was approved. He did have a question later on about where is the source of funds coming for you to repay this money and everything else, but he has various lines of credit, various business accounts there, and that's what we submitted. We submitted a letter of support from the bank itself saying, we know this person very well. He's banked with us for over 15 or 20 years, and that was enough for USCIS. Again, sometimes it's just a common sense explanation.
Yeah, actually, I was going to ask you that question, but just to reiterate, because we do get this question periodically, is it okay for an investor to borrow all of the $800,000 or to receive as a gift all of the $800,000 and use those proceeds to invest in the EB5 project? From a USCIS perspective, will they approve a 100% loan or 100% gift?
My answer is the same for both questions, yes and yes. Whether it's secured, unsecured, a gift, the analysis for us is always going to be the same. I think people tend to overcomplicate sometimes, or they get a little scared, but again, it's very common for a lot of investors for years to either get gifts or secured loans for the entire amount, right? From friends and family, from your holdings in real estate. For an unsecured loan, I do want our investors to provide a little bit more background about why this bank, this credit union, this lender loves you so much that they will give you all $800,000. Because again, a lot of times you kind of the law is the law, but it has to make common sense. If an adjudicator is looking at this and they see unsecured loans for $100,000, $200,000, but all of a sudden this person gets $800,000, there must be some sort of common sense explanation for that. And so I think if you have that, I have no issues with it.
So, I know we might lose Peter to a prior engagement that he has to get to, but I think we want to open this up for Q&A for questions. There's a couple things that have already been asked on the chat. We are going to run through the poll answers as well and kind of clarify some background and also some answers. And then if there's additional questions that are coming out of those polls, it's nice to see, a pretty good attendance here at 85 people or so at the peak. And I'm going to roll through these polls and we're going to talk about some of those answers quick. Looking at the responses in the beginning, there are 23 different people, or 36% of us are already invested in EB5. You've made your decision, you've invested, you've probably filed an I-526 petition, you are set. Your decisions were made, you're on your path, congratulations. Considering EB5 is another 56% of our attendees, and then not considering is 8%, potentially EB5 professionals or people here on behalf of other family or whatever it might be. But that means that 56% of us are looking at this data, looking at information, and wanting to make a better decision about what they might do in the very near future. Timelines wise, about 75, 78% of us are making a decision either immediately or relatively soon. And then, call it 20, 22% are putting this decision off into the future. So call it 70+% of us need to make a decision soon. So all this information we're looking at today really matters. How many rural reserve set-aside visas do you think were issued as of May 2024? How many green cards did rural achieve? Is there rural priority processing for real? The guesses are across the board. Very low number of 12, 25% of the people guessed there, another 25% at 153, 27% at 258, and another 23 at 550. That's almost an even distribution of guesses at really low, kind of low, not so low and high. And 550, compared to the amount of filings that are out there, is not even a really high number if everybody is magically marketing that rural has priority. So that's also the next poll question we should have asked is like, what were people told about how fast they would get a green card with rural processing? The answer for how many people got rural green cards so far in the rural reserve set aside category is 12 for 2 years plus. Rural has achieved 12 green cards.
Now, that is State Department data. We don't know if USCIS has actually given a few more, but like to your point, Colin, it's impossible
in the category.
Right. To get it.
The data we have says 12. We know there's dual approval codes being used out there. We know, or we were hoping that there's just more green cards in general, but the number out of DOS and the number that we have actually in our hands that everybody can take to the bank is 12. And then there's a whole bunch of amorphous and black magic going on what's behind the curtain at USCIS or whatever. But does 12 match the expectation of you are going to be giving priority processing if you invested in rural? You will get a fast green card is what we see on all the marketing. It's just not true at this point for everybody.
And it's critically important because that's consular processing. These are families overseas that chose an investment to get here fast. 12 have got the green card.
And the big difference, as you guys mentioned, is consular processing being overseas, needing that reserve set aside because you will get 0 immigration benefits because you're not eligible for concurrent filing. You're not going to get advanced parole. You cannot enter and exit the country. You cannot have employment, live and work anywhere in the United States that you want. You're at an extreme disadvantage versus the people that are already here in the U.S. and filing for EB5, whether it happens to be F1 students, H1Bs, L1s, otherwise. The consular processing visas, those rural set-asides were a major promise, and they have not lived up to it based on that statistic. So does that change your opinion on things? And when we ask, did you or are you planning to file with rural? Mostly because of that promise for priority processing. The vast majority at 55% said yes. It's because of priority processing that I made this decision. Well, there's 12 green cards and then another bunch that might be in the dual approval codes that we don't know. So based on data that they published, how does that make you feel? Then it kind of goes deeper into these sales pitches when we talk about the current visa bulletin and how, do we really understand how the visa bulletin works and what it means, and even more importantly, what it doesn't mean. And Peter does a great job with these videos on a visa bulletin update periodically. We post them on our YouTube channel at EB5, and he goes through how to read the visa bulletin, what it means, what it doesn't. But here we have a question that needs to be answered very clearly. About 80% of us are actually not sure what the visa bulletin is telling us. Or we know that the definition of backlog does not lie just with the visa bulletin. So as our gentlemen and our professionals mentioned earlier, being current is good. And it means that there's no backlog actually in and placed by the government. Whereas if you filed today, you would be eligible for adjustment of status if you had an approval in hand. So what that means is that you can also file your adjustment of status for those concurrent filers, the H1Bs, F1s, and everybody here, and you can get your EAD and advanced parole starting tomorrow with that petition if you filed while current. If you are, depending on consular processing, you will live outside of the country, you cannot do concurrent filing. You need to be current after your I-526E is approved. When is your I-526E going to be approved? That's what we discussed here on this webinar. Was it could be 6 months, 7 months, 12 months, 15 months. You need to look at the visa bulletin at that time to actually see if you're going to be current then. So if we go all the way back and you're looking at the statistics of I-526E filings and you're a rural filer today, where are you going to be after this whole clunkage of filings that showed up a quarter ago, 2 quarters ago? Is rural going to be current at that point when all those people go through? No, probably not, unless there's a massive amount of activity and all of the black magic of dual visa codes, the carryover visas, no visa wastage, maybe a whole bunch of withdrawals. Whether you get everybody in those lines that no longer need it, they get married, they get divorced. Some people maybe pass away, hopefully not. But, all these numbers will change significantly over time. But the marketers and the salespeople today for rural, are they telling you about that? So we just want everybody to have a full picture and making a smart decision before they make the final decision of filing an I-526E. Make the best decision that you can for yourself. So when we asked, how many of these individuals filed with rural, a whole plethora of individuals said yes. And then how important was that decision to have priority processing to make that decision to invest? 53% of respondents said extremely important. 25% said somewhat important. 75% of all respondents there said that priority processing is real, and that meant a lot to you to make that decision. 12 visas or 12 green cards, plus the black magic of whatever's behind. So are those 75% of people really satisfied with the service they've been given by everybody involved on that rural filing? Hope you had honest answers there. So on the partial capital contributions, we're not surprised by these numbers at all to have 75% say yes, 26% say no. Partial capital contributions is an extremely solid strategy and makes a lot of common sense, and especially for the vast majority of people here that are looking at asset sales, homes, stocks, any other assets where you're trying to get a good exit price to maximize your returns on the investment that you liquidated in order to invest. We see more and more people with more sophisticated funding strategies, and partials allow them to do that. So we're not surprised by those at all. So those are the answers to the polls and the guidelines. And that brought us back to the discussion of, well, if timing is something that is a little bit beyond our control for USCIS reasons, for unknown numbers and processing items or whatever might pop up, what can you do? If there's no shortcuts, there's no magic pill for this, you've got to select a project that's going to get you where you want to go, control what you can control, and get the most benefit possible to you. Rural and processing and HUA or any other category will not affect your repayment. Repayment is in your control. You can pick a project that has a shorter term length or a longer term length if that was your investment decision. Higher returns, lower returns, debt, preferred equity, common equity. You pick the investment. You control that. The best thing about the sustainment period guidance provided by USCIS is that they took the ambiguity out of it. Retrogression is not going to be there for 10 years, keeping you from your money, not allowing you to get through the process. People that are able to file post RIA have complete control of the investment decision and when they get back to their money and the business plan behind it. The immigration side, if you have concurrent filing, you have the AP, you have the benefits of the green card before you even have the green card in hand, you've done a lot already. So no matter what project you pick, you complete your sustainment period, your minimum investment commitment as per the offering, you can get your money back, plus the returns you were targeting and hope. You might have to wait a little longer for the final permanent green card, but as long as you have the EAD and advanced parole, you're probably about 90% of the way home, unless like your complete goal was naturalization and citizenship. We would have to wait a little bit longer. So turning that over to the really smart people in the room with Sloan, Greg, and Peter. Now, any thoughts about all that or the answers in these polls? Like, is any of this surprising to you?
Yeah, I'll jump in. It's not surprising at all. Investing in EB5 is, I would say, an emotional decision, meaning that there's the impetus to get to solve a visa problem. That means a lot to you and your family. And if you've been waiting in H-1B for years and you see a fast way out, you're going to look at it. You're going to give it serious consideration, which I get. And I understand that. But now we're at the point where regional centers should be very honest with processing times and expectations. I think there was a window where you could point at some positive data. I think that window is essentially closed, where rural and HUA both have similar opportunities to use unreserved visas in the future, but also constraints that could impact the aggregate time of approvals. Time will tell how things shake out, but it's really difficult to tell somebody with a straight face, I can get you a green card in a year. But people are paying to advertise that on Google still. And it's a little strange, but I saw it from inside the government. Now on this side, it's still going on, and it's surprising, but it's happening. Investors need to be selective about their partners at the regional center level and with their law firms.
Yeah. So we looked at a bunch of these numbers. We looked at the polls. We looked at things that were happening with USCIS. It sounds like, okay, we're kind of hoodwinked on the whole rural priority processing thing. But what are the good things that are taking place? The good things are the amount of actions that you saw USCIS take, and the processing has picked up massively. They are aware that they need to get through these green cards. They are handing them out like candy at this point. We had a day, less than maybe a month ago, we had 10 approvals in a day. So we had I-526s come through where it was just a massive packet of approvals that got sent out. They are rolling through all of those backlogs of petitions. Recent information made available to us, they are planning to churn through the entire backlog by the end of the year. So USCIS is endeavoring to do their service and to deliver what was promised at a massive clip. They are putting in those new processes. They are hiring like crazy. They have assured the market that USCIS's performance is going to escalate and stay at those escalated levels on a go-forward basis. So we expect to see a lot more production and a lot more petitions start churning through. And the overall crop of projects in the industry itself post-RIA is just really left with the pros. You've got people that were in EB5 before. They're all seasoned veterans. USCIS is able to get through these petitions faster because they're higher quality as well. So with that sustainment period, allowing shorter durations and quicker projects, with developers like us and our RISE fund looking at smaller, faster build and faster construction, you're having faster duration and much quicker construction and job creation. You're getting a lot more progress faster and getting through these projects much at a higher velocity than pre-RIA. So with all the benefits of concurrent filing, with all of the ability for sustainment periods to collapse investment periods for those that choose the shorter duration projects, the EB5 program is getting better. The performance is getting higher. There are policy gaps. There are things that weren't really fully thought out in the legislation. But the interesting thing about that is that we're halfway through the policy already. Fong, as you know, it was a 2022 policy. It was a 5-year deal, 4 years until all of the grandfathering sets in. We're halfway through it. You might see legislative gaps close, new bills proposed, and an improved EB5 program that has already delivered multiple billions of dollars post-RIA to the U.S. economy. That is a good thing for government to see. The items that were all being yelled about for the RIA policy and the legislation and the fights between senators and everybody else, those issues of integrity, the issues of transparency, issues of fraud, all of those are in the rear view mirror, and you're not seeing that as a commentary that is floating around EB5 today. EB5 has strengthened, it has gotten better, and these statistics are starting to prove that every piece of the puzzle is starting to come in. So there are good things happening here.
I agree with Colin. And part of it is like, there's a lot of noise being floated around. And also because I like to end things on a good note and focus on the positive as well. I've been in EB5 for a long time. Sometimes I forget, right? This is probably my 17th year. In my opinion, and this is for the good of the entire industry and for all our investors, we probably have a much more transparent, a much more safer, and a much more pragmatic program than we've had in years. USCIS is not perfect. We know they're not perfect, but there are changes that they've done and changes that Congress has done to help make things more palatable for everybody. One thing is the RIA is not perfect, but yes, it does put an onus on regional centers. It does put an onus on projects to act. Those of you who are worried about whether the regional center, the projects would be transparent, every single regional center each year has to turn in an auditing report to USCIS. USCIS is conducting site visits because they realize that, look, these investments, this program is important to not only your family, it's important to basically the economy of the U.S. Congress heard us long and loud about processing times. That's why concurrent filing is so powerful for so many people. It answers that question of when can I begin my life in the U.S.? I expect that around this time next year, we're going to have serious conversations about the next bill. I'm sure we're all going to have a lot of opinions and a lot of inputs to discuss. I know that our firm, the Bearing team, and everybody else will help push it through.
When 2019, we had some policy changes, right, related to the Modernization Act, and then COVID came in, and USCIS officers were facing a budget crisis internally. I got furlough noticed, so did my wife. Everybody in the bar, for the most part, 70% of us got a furlough notice and decided maybe there's another place for my expertise in Washington, D.C. And there was a big brain drain. After that, until the budget was recovered with the help of Congress, you lost a lot of people at the office, and position descriptions tend to expire. So if you want to increase hiring, you need a new position description. That needs to go through an internal component at USCIS. So before you can even put out a job announcement, you have to show that there's a new updated position description. And so this whole process took time. And then here comes implementation, boom, do all this work, right? And so working with one hand behind their back, I think that IPO has done a tremendous job. Some people will say they're too slow or point out where they're failing, but I think they're doing a tremendous job getting up to speed. I've been bullish on the future of IPO for a long time. And what we're seeing now, especially with increased fees, is the opportunity to hire and train and be more efficient. And we're seeing this now in this Q1 block here, that if we can get back to those 2018 levels, we can get to the point where we are just ripping through demand. And we got to a point in 2018 where we almost had to slow down because we were so efficient. And so I think the office is taking that step there. Time will tell. There's a lot of moving parts. There's a fee study that's due. There's more implementation questions that are unresolved, but I think they're going above and beyond expectations overall. And again, I'm bullish. I have been bullish on that office.
That's good. Fung, any final points that you'd like to make and or items that you've encountered here in this seminar? Anything you'd like to say?
No, I think we covered it for the most part. I'm glad we're ending it on this. I mean, a lot of practical information has been provided today. Look, we don't expect you to retain everything. The one good thing about our group and the Bearing group is, should you have any questions, should you have any concerns, whatever else, reach out to us. We are very accessible. We're more than happy to answer your questions. I think in order to get through this process with good conscience and a lot less stress, you want to feel like an informed investor with clear answers and with a game plan. So to the extent that we can help you out, reach out to us.
Yep, no, absolutely. And there are questions that we may not have gotten to. We're always open to talk one-on-one. So the appointment calendar is there in the corner of the screen. So if you want to get more information about us, EB5, things about track records, things about processing times, happy to talk about those individually. Again, 526s, 485s, wide range of things. But if you're going start to finish, for some of our individuals, I-526Es have been as fast as 7 months. The green cards have been anywhere from 15 to 24 months, but a lot of it is in process where it totally depends on your ability to turn around documents, medical exams, consular processing, making appointments for interviews. And then half the time, and Fung, I'm not blaming you or the attorneys, over probably 85% of the time that people do get a green card, we're the last ones to know because they got the green card, they're happy, and they're just living their lives, right? The attorneys usually know, but the regional center actually doesn't get direct notice from USCIS when this stuff occurs. We are not on the G28 form, which is typically your attorney who is representing you with USCIS. They're going to get the information, and unless you or the attorney voluntarily provides it to the regional center actually won't know until you tell them. And then, people show up a couple of years later and they're like, hey, I'm filing an I-829. And we look at it, it's like, well, we didn't even know you had a conditional green card yet. So always communicate with your regional center and let them know when those dates occur. Your attorney typically will not release your personal information to the regional center unless you tell them to. It's a privacy item. They owe you that confidentiality. So again, once you do get any kind of USCIS receipts, 797 notice of actions, issuance of a green card, and wanting to file an A29, you do need to communicate that to your RC and let everybody know where you're at. So that's a big thing. So I wanted to answer that question, but I know it's a wide range of numbers, and the worst answer that everyone doesn't want to hear, it depends. So unfortunately, it depends.
Look, if there's any delay with us providing you like notice that an investor got a green card, it's not out of malicious spite. We're probably too busy celebrating with them. It will come to you guys in due time. Okay, so that's all. That's all I got to say.
Fair point. Well, keep up the good work, Fong. We appreciate it. And the other attorneys that work with us, you know, we are always trying to be innovative and helpful and market leaders. And, you know, Fong, you've given us a ton of guidance over the years, and we look forward to a great future with KLD.
Thank you. Thank you.
All right,
Finish
well,
mutual.
thank you guys. Appreciate it all. If there's any other last questions, we can try and take something here at the very end. We will be posting the replay. We will have access to it and send it out to the attendees. We appreciate everybody joining us here today. We will continue these presentations and to deliver updates. The next update that could be significant, that we are expecting to be significant, is the response to our Freedom of Information Act lawsuit and mandamus filed against the government over 2 months ago. We are expecting data on current filing trends and a full breakdown from USCIS on how many petitions are filed, what categories, what they're doing for policy and hiring and actions. We are going to hopefully uncover a treasure trove of information that we will also present on a presentation where everyone will get deeper insight than even the numbers that we have here today. So we're expecting to present that hopefully in near future, and that would be a very interesting presentation for everyone here, whether you're already an investor or a future investor. All of that will be hopefully very insightful to all of us. So again, thank you for joining us, and we'll see you guys on the next webinar. Thanks again.
Thank you, everybody. Take care.
Thank you.
Thanks all.